The courtroom doors closed behind a woman who just lost everything. Not because justice failed, but because her own lawyer never showed up to 3 critical hearings, while still billing her $70,000. This isn't an isolated incident or a statistical anomaly buried in legal journals. This is the hidden architecture of a profession currently experiencing its most profound crisis of legitimacy in modern history. Across America, thousands of attorneys are stealing client funds, abandoning cases mid-trial, and fabricating evidence while state bar associations discipline less than 2% of credible complaints filed against them each year. The legal profession once represented the marble pillars of justice itself. But those pillars are now riddled with fractures that threaten the entire foundation of how society resolves disputes and protects rights. What happens when the gatekeepers of justice become the primary perpetrators of injustice, and the systems designed to hold them accountable have been captured by the very people they're meant to regulate? Michael Thompson hired a personal injury attorney after a delivery truck destroyed his spine, leaving him paralyzed from the waist down and facing $2 million in medical bills he couldn't possibly pay. His lawyer promised aggressive representation, secured his signature on contingency agreements, and then disappeared completely, not returning calls, missing filing deadlines, allowing the statute of limitations to expire without ever filing suit. By the time Michael discovered what happened, his case was legally dead. His lawyer had moved to a different state, and the state bar closed his complaint, citing insufficient evidence of intent. The legal profession operates under a paradox that would be laughable if the consequences weren't so devastating. Lawyers write the ethics rules. Lawyers staff the disciplinary boards. And lawyers decide which lawyers face consequences. This self-regulation model was designed in an era when professional honor meant something, when social shame could correct behavior. But it has become a shield protecting predators rather than a sword defending clients. Each year, approximately 15,000 formal complaints are filed against attorneys in the United States. But fewer than 300 result in actual disbarment, a conviction rate that would be criminal in any other justice context. The gap between complaint and consequence has created a moral hazard where the expected value of ethical violation far exceeds the risk of punishment, transforming misconduct from aberration into rational economic calculation. Sarah Chen spent 7 years building a small business before a commercial landlord violated their lease agreement, and her attorney advised her to accept a settlement of $12,000 for damages. She later discovered her attorney had secretly negotiated a side deal with the opposing counsel. They would split fees from quick settlements, while deliberately undervaluing her actual damages of nearly $300,000. When Sarah filed a complaint and hired a second attorney to sue the first, she learned the hardest lesson: the system teaches lawyers almost never testify against other lawyers, and courts almost never rule against them. To understand how the legal profession reached this point requires examining the architecture of self-regulation. A system built on the premise that lawyers possess unique expertise, making them uniquely qualified to police themselves. Every state operates its own attorney disciplinary system, but nearly all share the same fundamental design flaw. The investigators, prosecutors, and judges are all practicing attorneys with personal and professional ties to those they're investigating. In California, the state bar receives over 13,000 complaints annually but opens formal investigations into fewer than 8%. And even those investigations average 32 months to complete while evidence disappears and witnesses forget. The delay itself becomes a weapon. Attorneys under investigation continue practicing for years, accumulating new victims who have no idea their lawyer is facing credible allegations of theft, fraud, or abandonment from previous clients. Jessica Martinez discovered this when she hired an attorney to handle her mother's estate, unaware that he was already under investigation for misappropriating $1.2 million from 7 other estates over 4 years. He diverted Jessica's inheritance into his operating account, used it to pay his own mortgage, and luxury car payments, and continued practicing for 18 more months, before finally being suspended. Not disbarred. Just suspended. The economics of legal practice have fundamentally transformed over the past 3 decades, shifting from a profession grounded in service to a business model optimized for extraction and maximum billable hours regardless of client outcomes. Large firms now demand that junior associates bill 2,200 hours annually, which means billing over 42 hours every single week without exception for vacation, illness, or holidays throughout the entire year. This mathematical impossibility has normalized time padding, task inflation, and billing clients for work never actually performed. Practices that would constitute fraud in any other industry, but somehow remain gray areas in legal ethics. A recent audit of corporate legal bills found that 37% of time entries contained discrepancies, duplications, or charges for tasks that couldn't possibly have required the billed hours based on their nature and complexity. Yet when clients challenge these bills, they face an impossible choice: pay inflated charges to their current attorney, or fire them and hire a new attorney to review the old attorney's work, at additional expense. The student debt crisis has created perverse incentives throughout the profession, with new attorneys graduating with an average of $160,000 in educational debt, and immediate pressure to generate revenue rather than serve justice. These financial pressures trickle down to clients who become revenue sources rather than human beings with real problems, reducing representation to a transaction where the attorney's primary obligation is to their own survival, not the client's interests. Meanwhile, legal aid organizations that serve the poor operate on perpetual starvation budgets, creating a two-tiered justice system, where wealthy clients receive exhaustive attention, while the vulnerable are processed through assembly line representation, or no representation at all. The profession has stratified into castes: elite attorneys serving corporate clients with unlimited resources, struggling solo practitioners fighting for survival, and millions of ordinary people caught between them with nowhere affordable to turn when they need justice. But something fundamental began shifting in the late 2010s, when technology suddenly made the invisible visible. Social media gave victims platforms to share stories that professional gatekeepers had suppressed for generations, creating accountability through transparency. Jennifer Park's viral Twitter thread about her divorce attorney, who forged her signature on settlement documents, reached 4 million people in 72 hours, forcing the state bar to finally act after ignoring her formal complaints for 3 years. The thread triggered an avalanche. 237 other clients of the same attorney came forward with similar experiences, revealing a pattern so systematic that even the disciplinary board couldn't maintain its traditional posture of skeptical inaction. Traditional media outlets, sensing the shift in public consciousness, began investigative series, exposing what legal insiders had known privately for decades. The disciplinary system wasn't failing accidentally, but functioning exactly as designed to protect the profession. A Pulitzer finalist investigation by the Tampa Bay Times revealed that Florida's Bar Association had allowed attorneys with multiple theft convictions to continue practicing, while fast-tracking disbarment for lawyers who criticized judges or exposed prosecutorial misconduct in public forums. The hierarchy of professional protection became undeniable. Attorneys who stole money faced gentle treatment and second chances, while those who threatened the system's legitimacy faced swift and permanent expulsion from the profession regardless of client harm. State legislatures, responding to constituent pressure, began introducing bills to add non-lawyer public members to disciplinary boards, mandate transparency in complaint processes, and create independent oversight mechanisms separate from bar association control. Reforms the profession had resisted for 50 years. The organized bar fought back with overwhelming lobbying power, warning that unqualified citizens couldn't possibly understand the nuances of legal ethics, and that outside oversight would destroy attorney-client privilege and undermine the entire justice system. Arguments that had worked for decades. But this time the arguments landed differently because the victims weren't abstractions anymore. They were constituents with documentation, they were organized through online networks, and they were angry enough to vote on this single issue. Utah became the first state to establish a genuinely independent legal services oversight committee with majority, non-lawyer membership, and subpoena power, creating the template other states would watch carefully to see whether reform was possible, or professional capture was inevitable. Within 18 months, Utah's committee received over 900 complaints and opened 147 formal investigations, more than the previous bar-controlled system had opened in the prior 5 years combined, suggesting the backlog wasn't about resources but about will. Technology companies began developing artificial intelligence systems to analyze legal bills for fraud patterns, offering corporate clients tools to identify the padding and duplication that manual review could never catch at scale across thousands of invoices. When these systems analyzed 5 years of legal bills from Fortune 500 companies, they identified an estimated $3.7 billion in probable fraudulent charges, a number so staggering that it couldn't be dismissed as edge cases or honest mistakes. The profession faced a legitimacy crisis of its own, making public trust in lawyers had fallen to 23% approval in national polling, lower than Congress, lower than journalists, approaching the territory reserved for used car salesmen and telemarketers. The question was no longer whether the system would change, but whether it would reform from within, through genuine accountability, or collapse from outside, through technological replacement, deregulation, and the complete loss of the professional monopoly attorneys had enjoyed for over a century. The stories that opened this investigation, Michael's stolen justice, Sarah's betrayed trust, Jessica's plundered inheritance, represent more than individual tragedies. They illuminate the human cost when society's designated guardians of fairness abandon that sacred responsibility for profit. What emerges from examining thousands of similar cases is a pattern that transcends individual morality. This is what happens when any profession gains the power to regulate itself, without meaningful external accountability or consequences for systemic failure. The medical profession learned this lesson through patient safety movements that forced transparency about surgical errors and hospital-acquired infections, disclosures that initially felt threatening, but ultimately improved outcomes, and restored public trust through demonstrated commitment to improvement over protection. Banking learned it through federal regulators with enforcement power independent of industry capture, creating systems where individual institutions might fail, but the sector maintains credibility through visible consequences for fraud and misconduct that actually deter future violations. The legal profession now stands at its own reckoning point, and the path forward requires something attorneys claim to value above all else: the courage to let evidence and outcomes speak louder than tradition and professional self-interest. Some states are pioneering alternative approaches. Arizona eliminated the requirement that law firms be owned solely by lawyers, allowing competition and innovation while maintaining ethical obligations. And early data shows increased access without the catastrophic consequences opponents predicted. Washington state implemented mandatory bias training and created early intervention programs that identify struggling attorneys before they harm clients, treating professional decline as a treatable condition, rather than simply waiting for disaster and then punishing it. Technology platforms now allow clients to review their attorneys' publicly imperfect systems, vulnerable to manipulation, but creating market accountability where professional accountability failed, forcing attorneys to care about reputation beyond their immediate peer network, because clients can finally compare experiences. Yet resistance remains fierce from those who built careers within the protective system, who see any external accountability as an attack on professional independence rather than a necessary evolution toward earned, rather than assumed trust. The ultimate question isn't whether lawyers are inherently more corrupt than other professionals. It is whether any group of humans can be trusted to police themselves without independent oversight, transparent processes, and genuine consequences that create incentives stronger than tribal loyalty. For Michael, Sarah, Jessica, and the hundreds of thousands like them who experience the profession at its worst, reform won't restore what was taken. The years lost, the justice denied, the faith in institutions shattered beyond repair. But their willingness to speak despite knowing the system was designed to silence them has created the possibility that future clients might encounter a profession that actually lives up to its stated ideals, rather than hiding behind them. The legal profession's ethics crisis isn't a story about a few bad actors corrupting an otherwise noble system. It is about what happens when noble intentions meet human nature, without the structural constraints necessary to keep aspiration aligned with action. Every profession faces this tension, but few professions hold such concentrated power over citizens' most fundamental rights: property, liberty, family, justice itself, making the stakes of regulatory capture uniquely consequential for democratic society's basic functioning and legitimacy. The ethics crisis in legal practice will be resolved one way or another, either through painful but necessary reform that rebuilds public trust by earning it, or through slow collapse as technology and public disgust erode the profession's monopoly, until the ethical question becomes moot because the profession itself has become obsolete. The choice facing the legal profession is the same choice facing all of us. Do we demand accountability even when it is uncomfortable? Or do we accept corruption because fixing it seems too hard? Every comment you leave, every share you make, every conversation you start, that is how broken systems finally break. If this story mattered to you, hit that like button so YouTube shows it to more people who need to see the truth. Subscribe, because we're not done exposing the hidden mechanisms that shape your rights and your life. And drop a comment telling me, what profession should we investigate next? Because when we shine light on darkness together, darkness loses. Thanks for watching. And remember, they're only untouchable if we let them be.